Morning and welcome everybody to this morning's Employment Equity webinar. My name is Nikki Hardwick. I'm the Human Resources Consultant from HR Talk. I also head up the HR division of HR Talk. I have been dealing with employment equity for approximately 20 years and so have gone through the various changes as well as dealing with the amendments that were to come into effect and then have not come into effect. So today what we're going to be doing is just talking very broadly about what is expected of employment equity. Why do we need employment equity, or at least why is it in place at the moment? So what does the legislation say? What are the requirements of a business who is designated? And then I am going to spend a little bit of time just going through some of the amendments, although they have not come into effect at this point in time. They will be coming into effect in the next, we hope, next year. So it's just to understand how does that affect you and your business. And then also as a small employer, i.e. somebody who is under 50 employees, how does that affect you? Please feel free to pop any messages that you need within the Q&A. So if you have any questions, and then I will try and address them as we go through the presentation. Okay. So stepping into the actual presentation. So if we look at the Employment Equity Act itself, so the Employment Equity Act is a piece of legislation. So in essence, what it means is that there is a legal requirement for certain employers to comply. There's really two elements to the Employment Equity Act, taking into account that these, just to confirm as well, is that the Employment Equity Act came into effect in South Africa in, I think it was either 1999 or 2000. So it has been in South Africa for a number of years. And there's really two elements to the Employment Equity Act. The first one, which applies to every single employer in the country, whether you have one employee or you have 5,000, it doesn't really matter. But the first element was to develop a space in which there was a requirement of employers to eliminate unfair discrimination within their workplace. So that applied to every single employer within South Africa, and any single employee who felt like they were the victim of unfair discrimination has the ability within the Employment Equity Act to go and refer a matter to CCMA. So that is not unique to only designated employers. It applies to every single employer within South Africa. What is nice about the Employment Equity Act is it defines for us what is unfair discrimination, and I will go through that with you in a moment. The second element of the Employment Equity Act was the implementation of what is called affirmative action measures within the workplace to address any disadvantages, otherwise known as possible barriers to employment equity. Now, an affirmative action measure is not specific to a particular group of employees, and it's not particular to a group of employees within the country. So how affirmative action would work is in your particular organization, what you would need to do is to compare your organization to, at this point in time, the economically active population. And you would then need to decide, based on what your workforce looks like at the moment versus the economically active population, where are you underrepresented? So for argument's sake, if we have the economically active population that says currently those that are willing and able to work, there's 54% of them are men. When we look at our workplace, we find out that we have 80% females. So now we need to, as an organization, is to establish why do we have such an overrepresentation of females, or conversely, why do we have an underrepresentation of men? At that point, we then start to, with our committee, start to identify, are there any barriers to employment equity? So if we take nursing, for example, there's going to be a large overrepresentation of females within that particular industry, and there is at the moment. So within nursing, they would then need to establish what is the barrier, or are there any disadvantages that are faced by men in that particular industry? And if there are there any affirmative action measures that we could possibly put in place that would help eliminate those barriers? Another example to try and understand affirmative action measures is if we took a person with a disability. For the purpose of this conversation, we would take someone who had a physical disability. We could take someone who was in a wheelchair. if our workplace was not conducive to someone in a wheelchair, it wouldn't matter if they applied for the position, if they were suitably qualified and able to come into the workplace, there would be a barrier or a disadvantage by virtue of the fact that they possibly could not go through the doorways, there was no bathroom available, and the workplace was not suitable to that person in a wheelchair. And so the barrier to achieving our employment equity, i.e. getting a certain percentage or people with disabilities into our workplace, the barrier is that our workplace is not conducive to people with a disability, specifically people in a wheelchair, and our affirmative action measure could be that we are going to create a bathroom or change the bathroom so that people can be accommodated, possibly change certain things around the workplace. So as you can see, hopefully by my examples, is that affirmative action is not a countrywide thing that is applied to specific groups of people. You within your organization need to determine where are you underrepresented in terms of the economically active population? Why are you underrepresented? So are there any barriers to employment equity? And those barriers could be internal versus external. And then are there any affirmative action measures that can be put in place to assist you in achieving employment equity in all of those different levels? Okay. So if we then take one step back, as I've said before, just to recap, there's really the two elements of employment equity. The one is the elimination of unfair discrimination, and the second one was to implement affirmative action measures to try and redress disadvantages and in essence try and rectify any imbalances that we have within our workplace. As I mentioned before, what is nice about the Employment Equity Act is it defines for us the different elements of unfair discrimination, and I'm going to go through those now. So the first one, which is probably the cornerstone and is often referred to in the other elements of unfair discrimination, is what we call Section 6.1. And this section says that no person may unfairly discriminate either directly or indirectly against an employee in any employment policy or practice on one or more of the following grounds. And then it goes on to list those grounds. So it includes race, gender, sex, pregnancy, marital status, and it goes on, and then it ends on any other arbitrary ground. And in essence, what this means is, as you can see on the slide, is it says that there may not be unfair discrimination. So in essence, what this means is that it says, as an employer, we cannot make a judgment call based on one of these things and this thing alone that a person can or cannot do the job. So very, easy ones to try and give a similarity to is, as an example, we could say, I have a department within my organization that is admin orientated. So very highly admin intensive, needs lots of organizational skills, must be able to multitask, and must be able to do a lot of the admin work for whatever purposes. So I believe, and this is just again for the purpose of this particular presentation, is I believe that men cannot do admin, they cannot be organized, and they cannot multitask. And so any male that comes to work in my organization, I will automatically exclude because the person is a male. Now, if we look at this particular section, that would be unfair discrimination, because we cannot just make a judgment call that because someone is male or female, that they cannot do the job. Another example, if we're looking at gender, and I do hear this all the time, we could have, for example, I don't employ women of childbearing age because they're going to go off and have babies, and then there's the 4 months of maternity leave, and then obviously when the child is sick, etc., etc. So we don't employ women of childbearing age. Now, what happens in that scenario is that we're making the assumption that all women want to have babies, all of them are going to have babies, and they're going to now impact my work environment. And so due to family responsibility, I just make the assumption that they're all going to do that, and I exclude them from any process. So that could be promotions, it could be training and development, it could be anything within the organization. I just exclude them. Another example could be, if we look at females again, we could say from a construction perspective, our workplace is very, very labor intensive. And so we don't employ women because obviously women shouldn't be lifting heavy things. Now, again, if we go back in our country, and the reason why we have this legislation is there was a time where people either were chosen or were not chosen based on a particular element within here. So that race and gender, or ethnic or social origin, or whatever it is. So what this element is saying is that you cannot just on this alone decide that the person can or cannot do the job. What you are able to do is to fairly discriminate against someone. So take disability, for example. If you're looking at an airline pilot and the person comes in and they're blind, inherently they cannot do the job, and therefore that would not just make quick judgment calls based on one thing without having a justification. Okay. Moving on, so one of the things here you will see is that no person may unfairly discriminate against an employee. Now, if we go to who is an employee, now this is specifically relating to harassment and relating to employment equity. And it's quite important for you as an employer to understand how is an employee defined for employment equity purposes, because it is different to various other pieces of legislation. So when we look at who is an employee for employment equity, i.e., who can make the job and make a claim of unfair discrimination at CCMA. It also includes volunteers who assist in carrying out or conducting the business of the employer. So the fact that a volunteer is not employed, they too have the right to make a claim of unfair discrimination if they are helping you within your business. So the definition of employer is greater, and why that is important is that you as an employer need to ensure that within your workplace that you are extending and ensuring that your managers are properly trained to ensure that they are treating the people that wouldn't ordinarily be defined as an employee as if they were an employee for the purpose of employment equity. Okay. If we then have a look at the second element of unfair discrimination, this is equal pay for equal work. Now, people often get confused as to what does this mean, but inherently what it means is that if we look at any terms and conditions, so it doesn't just relate to remuneration, it is any term and condition of employment, we are not as employers allowed to have a difference of terms and conditions, which includes remuneration, between two employees who are at the same employer doing the same or substantially the same work, if that difference is related to something in section 6.1. Then that would be unfair discrimination. Now, there is a code of good practice that allows us and defines for us what is the basis for having differences and fair discrimination in terms of having differences. A lot of people understand this to say, well, now that we have equal pay for equal work, regardless of my years of service, regardless of whether I perform properly or not, everyone must have exactly the same amount of money. We must all have the same terms and conditions, and that is not what this says. It asks employers to look at what people are getting paid, what are their terms and conditions, and identifying if there is a difference. Why is there a difference? And is that difference related to something in section 6.1? So in other words, we've got a male and a female. Male earns substantially more than the female. We don't know why. And it's possibly because, I don't know, for example, male just earns more because he's a male. In that situation, there is an obligation for us as employers to try and rectify that imbalance. But if you have people that have differences in terms and conditions, so for example, Nikki has been here for 20 years, Sally's only been here for 5, Nikki's got substantially more experience, I'm well within my rights as an employer to pay Nikki for her experience versus Sally, who doesn't have any experience. So that is what this section refers to. Then we get into the third element of unfair discrimination, and that is harassment. So there's a code of good practice which was updated last year in March, which defines for us what harassment is in the workplace. And I want to just be clear, in terms of harassment, this also includes people that are not employed by the organization. So when we look at who, so the wording, I don't like the wording of victim, but it's just so that everybody can understand, but who can be both a victim of harassment in the workplace as well as a perpetrator. It is larger than just those people who are employed in your workplace. So if we look at the slide, you can see there's the standard that everybody would really understand, but it goes on to say that both volunteers, clients and customers, suppliers, contractors, and pretty much any other person having dealings with the business can make a claim of harassment either against your staff or volunteers or interns or people just coming in for a job can also make a claim of harassment against one of your employees. Now, why this is important is because there's an obligation on you as the employer to do, and we'll talk about it just now, but you as an employer cannot just limit your responsibility to the people that are employed. There is a greater responsibility to ensure that your staff are protected, as well as to ensure that people that are coming into your business, not necessarily those that are employed by you, are protected against this unfair discrimination. And if you fail in your obligation to protect people, the consequence is that you could end up at CCMA being liable for the behavior of the person who harassed whoever it was, the victim. Okay, so this is quite an important thing, and this is actually a training all on its own. So if you're not clear on this, please feel free to email us afterwards and we can give you a little bit of guidance. But this is quite a big thing at the moment, and it's more than just equity, but it is also part of employment equity. So when we just have a look at where are employees protected from harassment, so I'm not going to go into each of them, but you can see that if we look at where people are protected from harassment, it's pretty much any situation or any place that the employee is as a result of their work. So that includes social events. Even if you go on a team building and after the team building, people are socializing, the reason that people are at that event was because they were put there as a result of work. The same applies to things like conferences, Christmas parties, work-related trips, any of those kinds of things where the person is there or people are there as a result of work, is there is a responsibility on the employer to ensure that people understand, one, how they need to behave, and two, if something happens, what do they do in order to make a claim, if that makes sense. So as the employer, you can see how your responsibility is greater than just making sure that your office is protected. Okay, in terms of harassment, it is broader than just sexual harassment. So it includes things like bullying, it includes obviously constructive dismissal, there's sexual harassment, there's racial harassment. So it is greater than what everybody traditionally understood, which was sexual harassment. It is now broadened to a lot of different types of harassment. And so it's important that as an organization, you are teaching people what they need to do. What is nice about the new code of good practice is it does define for us how we determine if something is harassment or if somebody is just unhappy about a behavior that has happened. And so it gives us a test that we need to do. The first one is, was the conduct unwanted or did it impair dignity? Did it create a hostile or intimidating work environment? And is it related to one or more of the grounds in section 6.1? So just a reminder, the section 6.1 related to race, gender, sexual orientation, age, pregnancy, family responsibility, and a number of other things. So this is the third element of unfair discrimination. There is a lot more to it than just these slides, but it's important that you understand. Okay, the fourth element of unfair discrimination is medical testing. So in essence, we're not allowed to do medical testing for the purpose of excluding or preferring a person unless the medical testing is required by legislation or legislation permits the testing, or it is justifiable to do so in light of medical facts, employment conditions, social policy, and fair distribution of benefits, or the inherent requirements of the job. So for a new employee, and or if you're going to be giving someone a promotion, you cannot just do a medical to decide whether or not the person can get the job, or exclude or prefer a person if you don't have any justifiable facts. Okay, otherwise it would be unfair discrimination. Okay, so it is not unfair discrimination to take affirmative action measures consistent with the purpose of this act, or distinguish, exclude, or prefer any person on the basis of the inherent requirements of the job. So just to unpack that very broadly, is what we allow to do is that if we have people, so we don't just have to employ people, to try and meet a number, we do have the ability to say to a person, in as much as you may be the right gender, you might be the right race, you do not have the required skills, and therefore I cannot employ you because inherently you cannot do this job, and that would be fair discrimination. We also have the ability, on the other hand, if we look at point A, is we have the ability, if we have an employment equity plan that says that we want to, for argument's sake, employ a female in this position, or an African female, or just females in general, and we exclude men, even suitably qualified men, to try and achieve the objectives of our plan. If that man or male, or whoever it was, went to CCMA and made a claim of unfair discrimination, we would be justified, if it was in our plan to say that that is what we do, we would be justified, and it would not be unfair discrimination. Okay, all right. So now we just go into, so those are the elements of unfair discrimination. There is a fifth element of unfair discrimination, which I haven't listed in the slides, and that relates to psychometric testing. Now, psychometric testing is already, there's already rules around if a psychometric test is valid and justified and that kind of thing. But in essence, what it says is you can't use psychometric testing to exclude or prefer a person if that psychometric test does not meet minimum requirements. And those minimum requirements are generally defined by the Health Professions Council, but you cannot just make up a psychometric test to exclude or prefer someone solely on that basis unless that psychometric test has met the minimum requirements. Okay. So now we get into, so everything that I've spoken about at this point in terms of unfair discrimination applies to every single employer in South Africa. And again, when we look at employer, we look at employee. If I have an organization, I don't physically employ people, but I have volunteers, that section applies as well. So it is anyone who comes into my business for the purpose of assisting me in running that business or doing whatever it is required is covered by the elements of unfair discrimination. So those 5 elements: harassment, equal pay for equal work. Obviously that won't work with a volunteer, but any section down there will apply to an employee as defined as what we've spoken about. Now, we now have designated employers that are required to do additional things. So that is what we're going to go to now. So I'm going to explain what a designated employer is and then what the requirements are for a designated employer. So this does not apply, the sections that I'm going to be talking about now, to non-designated employers. Okay, so there's been a lot of confusion, just to be clear, there's been a lot of confusion up until this point with the changes in legislation, because the changes in legislation had the elements of the turnover for those that are under 50. Now that legislation, the employment equity legislation, has not been put into effect yet. And so currently the designated employers are anyone who employs more than 50 employees. And if you employ less than 50 employees, but your turnover exceeds or equals the turnover in your particular industry as detailed in Schedule 4. If you don't know what Schedule 4 is and you are under 50, please email us afterwards so we can send you a copy of that Schedule 4. If your turnover is more than what is listed in the Schedule 4, even if you have 3 employees, then you may be designated and are required to do what I'm about to explain to you. The consequence, to be clear, of not doing that is that there are fines of up to 1.5 million and 2% of turnover if you are audited and if you are referred to not Department of Labor if you're referred to court because you failed to comply. So it's very important for this year. They're looking at doing the changes going forward, but we don't know when those are going to come into effect. So we don't know when under 50 will no longer be designated. So at this point in time, if you're under 50 and your turnover exceeds it, then you are designated and you do need to submit this year. So for the purpose of this conversation, designated employees is more than 50, or if you've been appointed by a collective agreement and these other elements here, or if your turnover is more than what is specified in Schedule 4, then you are designated and need to comply. Okay. So these are the requirements of a designated employer. So I'm going through as if you've never done any of these things. You're a brand new employer who has now become designated. There is a specific process that you would need to follow. Okay. So first and foremost, you need to assign an employment equity senior manager. You can apply, or at least assign, more than one employment equity senior manager, but this needs to be done in writing, and there are specific requirements of that employment equity senior manager. Now, in essence, what would happen with this person is their responsibility is to implement and to monitor employment equity within the business. Okay, it is not just a title, it's not just the person that signs off the report. Their responsibility is to ensure that equity happens within the business and transformation happens, that they're implementing the plan and that they're doing what is required. So in essence, when we look at what it actually means is that if in a year's time or 2 years' time or whatever, an audit is done and the Department of Labor finds that employment equity hasn't been implemented, you can go back to your senior manager and say that you have not performed in your duties, and that person could possibly be disciplined or dismissed. That is what it means to be assigned as an employment equity senior manager. Okay. So that must be done in writing. There is a specific format that it needs to be in writing, but you appoint the person as the EE manager. Secondly, what we need to do is we need to do communication, awareness, and training. Now, this must be done on an ongoing basis. How it must be done is not really specified, but it needs to be done in a way that works within your organization. Part of this communication, awareness, and training is developing a communication strategy for within your organization specific to your organization. So there needs to be a strategy that says, how are we going to do this? Do we share information via notice boards? Do we do it in our toolbox talks? Is it something that happens on Teams? How are we going to be disseminating information? When are we going to be doing it? And how often? And who is responsible for doing this? But the types of things we need to be talking about is what is the Employment Equity Act? What is discrimination? What are diversity issues? And I'll talk about it now, but also what is harassment in the workplace? So we constantly need to be communicating and making people aware of these issues within the workplace. Okay. Then we get to step number 3. Now, obviously, if you've done some of these things, this doesn't necessarily need to be the order. So if you've done the EEA ones, then obviously you remove that out of the step. But this is going through as if you've never done any of these things. Then we need to do our EEA 1, which is our employee declaration. That EEA 1 will be a declaration in which I, as the employee, am requested to sign, and I specify on there, am I African, Indian, colored, or white? Am I male or female? Do I have a disability, or am I a foreign national? There was a question posed at the Employment Equity Roadshow that I went to last week in terms of, do we have the ability for people who identify differently, who don't identify as male and female, or possibly don't want to identify as African, Indian, colored, and white? That is not in the pipeline at the moment. They have not got to that point because, unfortunately, the stats at this point only align to African, colored, Indian, white, foreign national, male, and female. So a person within your organization does have the right to refuse to complete that form. They don't have to complete it, in which case you as the employer must make assumptions. So if you look at a person, they haven't completed the form, you will make assumptions on what you think that that person is. It may be right, it may be wrong, but if they don't want to fill out the form, that is their right to do so, and then you will just record whatever you believe that they are. Okay. All right. I do notice there's a question. I'll get into the question shortly. Just in terms of those forms, because of POPI, those forms are kept separate to your employment equity file. So you would keep them separately to that file because it contains confidential information about individuals. So you would request people to complete the form. If they did not complete the form, you would make a note that they chose not to, and then you would keep that information in a file so that you could accurately go, Nikki is a white female, she's South African, and she does not have any disabilities or whatever it is. And then you would get that information. Just to be clear as well, with that form is people have the right to change the information, but you also have the ability to question what they're changing it to. So a person cannot change every month what they feel like doing, because obviously you're reporting on data and that data needs to be accurate. But if I'm going to change, so if I go and change my, if I go and have an operation and I change from female to male, if there's certain processes in place and I wish to do that, then I would go to HR and request that change. But it can't be changing male to female because then it affects our reporting. Okay. Then we need to appoint an Employment Equity Committee. Now, that Employment Equity Committee must be representative of all stakeholders. Ideally, they need to be elected and not selected. So in other words, what that really means is within my organization, I don't just pick the people that are going to say what I want them to say. Remembering that the Employment Equity Committee is not another negotiation forum. So it is not there meant to negotiate on certain issues. It does not take the place of a trade union. It does not take the place of HR. It is an advisory committee to try and bring information into the committee to help identify barriers to employment equity and identify possible affirmative action measures. So the people that are on that committee are coming in with a particular view, so they will see things from their perspective. They can bring information in that possibly people at top management don't see. So ideally, we need to have a broad committee that has representation from all different facets within the organization, even those that are not designated. So if you have white males within your workplace, there must be a white male that is presented on the committee. So it needs to bring everybody in there. And what they need to do is to meet on a quarterly or monthly basis. And this is to line up with the monitoring and evaluating mechanisms. Just to be clear as well, ideally you do need to train your committee so that they understand what they're required to do. So again, as I say, it is not another workplace forum. It is not a skills development committee. It is different to a skills development committee. There are specific things that need to be discussed within the Employment Equity Committee. So you cannot have an equity committee that only ever talks about skills, because equity is greater than that. Okay, so then you need to meet quarterly. There's obviously things that need to be presented, but your equity committee is there to talk about employment equity issues, identify barriers to employment equity, bring equity issues to the committee so that we can recommend changes. All right, then we need to conduct a workplace analysis. Now, this is quite important, and this happens prior to us doing our employment equity plan. It happens prior to us submitting our EEA2. This is something we do at the beginning. And in essence, what we have to do is we have to look at our workplace. So at a particular time, we have to look at our workplace, and we now, at this point in time, compare our workplace, or at least our numbers, to the economically active population. And we have to look at our workplace in the various different levels, and we have to identify where do we meet where are we the same as the economically active population, where are we overrepresented, and where are we underrepresented. And that may be different in the particular levels. Then what we have to do specifically with the committee is we have to identify, as I've mentioned in the beginning, why do we look like that? So why do we have an representation of males, as an example? Why do we have an overrepresentation of females? Why do we only seem to have this particular gender? Why do we not have people with disabilities? What are the barriers? So what is stopping us from being able to do that? So we need to do assessments, we can do surveys, we can chat to the committee, but we need to start to unpack, why do we look like we look? Bearing in mind that the barriers to employment equity could be internal barriers, So it could be the way that we do recruitment. It could be that there's a culture within the business that the people within the business, the employees won't accept change. So if somebody new comes in, it could be a male-dominated workplace, and they don't believe that females can come in. And so it's really difficult to change. So it could be an internal thing, it could be recruitment, it could be that there's no turnover, or it could be something external. So an external factor could be that within the particular area that you're living in, majority of the people are a particular race group, and you're very far away from everybody else. And so the challenges are greater because you can't get people into the area. So there could be both internal and external. As I said, for example, if we look at the nursing space, that is going to be predominantly female. And the barrier to employment equity in that space is that even if we employed males and we gave preference to males, there's still going to be a far a greater amount of females that are now going into nursing than there will be males. So the proportionate rate of employment is going to be according to who's going into the field. So that is an external barrier that we may not have control over, but it's a barrier nonetheless. Okay, so once we have done our workplace analysis, we now look at our numbers, we identify what our barriers are, we suggest affirmative action measures. So we go, we think this might work, we think this might work. What are the things that we're going to try and put in place to try and eliminate those barriers? Then we put that on our EEA 12. You must use the format of the EEA 12, which is given to us by Department of Labour. You cannot do your own format. You must use the one that they've given. Just to be clear, when we're looking at the demographics and we're looking at what are we comparing ourselves to, is that at this point in time, you compare yourself to national. And if you're regionally based, then you also compare to the region. So if you're only based in KZN, as an example, you will compare yourself to KZN and national. Okay, that is how it is at the moment. Obviously, when we're looking at the employment equity amendments, they talk about the sector targets, which I'll talk about later. But at this point in time, we're still looking at the economically active population that is given to us by Department of Labour in our Employment Equity Commission report. So that was given to us, I think they shared it in March. So if you don't have a copy of that, you're more than welcome to email us and we can send you a copy of that report. I think you can also download it off their website. Part of this analysis is also now conducting a harassment risk assessment. So there is a requirement in line with employment equity as well as the Code of Good Practice for employers to conduct a risk assessment on the workplace in relation to harassment. So this is part and parcel of compliance within employment equity. If you don't know what to do in that space, again, please email us. Then coming out of our EEA 12, where we have identified what are our shortfalls, where are our barriers, what are our suggested employment equity measures, we will then put in place an employment equity plan. Okay. At the moment, and this may change down the line, or will change down the line when the legislation comes through, is currently we have the ability to choose a plan of between 1 and 5 years. We must use the EEA 13 format. We cannot define our own format. Excuse me, we must use that format. So we take the information that is given to us on the EEA 12 and we put that onto the EEA 13 format. That document must be signed by the CEO. Okay, it is really important that you understand that you must. So one of the things that is key to compliance is you always have to, if you are designated, you must have a current plan, so it must still be active. It must be signed by the CEO. And if your plan is about to expire, you need to ensure that you have a new plan that is in place, so the minute that the old plan, so you can never be without a plan. If Department of Labour does an audit and there is a period of time that you do not have a plan, they can refer you directly to Labour Court. So it is imperative that you make sure that as soon as your plan is coming to an end, I normally use the time frame of going a year before your plan starts to come to an end, you need to start consulting and start looking at your analysis. Because the idea is that on your employment equity plan, it says there that ideally you should have your new plan that comes into effect when your old plan expires should be in place at least 6 months before your plan expires. So ideally, you should start the process of consulting, identifying, doing surveys, doing your snapshots. You should start the process at least a year before your current plan expires. As we move into the possible changes to legislation, what they've explained at the various roadshows is that going forward, when the change comes into effect, every single employer, regardless of what you want to do, will have a plan that will be 5 years long. So if it comes into effect next year, our plan will, everybody's plan will automatically, regardless of whether you have a plan or you don't, will then run from the 1st of September 2024 for 5 years. So everyone will be exactly the same. You do not then have the option of doing a 1-year plan, a 2-year plan. We all do exactly the same. We will also then be required to meet the sector targets, which will then be at the end of the 5 years. Okay, so everyone's plan will then run 1st of September 2024 to the 31st of August 2029. Okay, so that is going to be how it changes. At the moment, though, we use the current format. We can decide how long our plan is going to be. It can be anywhere between 1 and 5 years long. It must be signed by your CEO and it must be current. Okay, so that is really, really important in case you are audited. Then we have the monitoring and evaluating mechanisms. So it's imperative that you keep records. You must put in place monitoring and evaluating mechanisms. So looking at your plan, identifying what did we say we were going to do, and then starting to look at why are we not doing it. It's pointless putting in place a plan. You put it in place, everyone signs it, and then we don't look at it again, until we need to do a new one, because the purpose of a plan is to go, we said we were going to do these things, and then holding people accountable, i.e. the senior manager, the HR person, whoever it is, to say, these are the things that we agreed we were going to do. Why have we not done it? Okay, so this starts to become quite important when we do the new legislation, because that's going to be one of the things that are going to have to be answered when we're looking at our compliance certificate. But it's important as the committee that they have cited that document. What did we say we were going to do? Why are we not doing it? Do we need to change things? Did we put something in place and it hasn't worked? So we constantly need to be trying to identify what are the challenges that we're having and how do we start to fix it. And then this is actually the element that everybody seems to know about, is the submission of your EEA2 and your EEA4, which is required to be done online every single year between the 1st of September and the deadline is the 15th of January. So everyone knows about these. What the key thing is, and what a lot of employers don't know, is that they'll do the EEA2 and EEA4 and then sometime down the line kind of do their plan. The process that I've explained to you is actually how it should be done. You start with your analysis, you do your plan, and then your EEA2 is actually almost a progress report that you submit to Department of Labour so that they can see, are you progressing? Are you moving forward? It's not the other way around. It's not the EEA2 and then you kind of see what happens. Your plan is what you say you're going to do. So that actually comes first. Okay. Alrighty, okay, so I'm just checking time. Okay, so now what we're going to do is I'm just very briefly going to go into some of the amendments. I'm going to talk about the solidarity settlement agreement and explain what is going to happen as we go forward in terms of possible changes and the kinds of things that you need to do within your organization. So if you're not aware, there's really just 3 significant changes that have been that are within the amendments. We're still waiting for the president to sign those amendments. So they have been gazetted, but the president needs to sign when they're actually effective from. So it is there, they've all been signed off, but there's no effective date. So at some point, the president will sign and say, now the changes to employment equity, the amendments will come into effect on that date. Okay. So in essence, there's the one change that I said is that anybody that is employing less than 50, okay, but the turnover is more, or whatever it is in terms of Schedule 4, are designated employers. Going forward, that will change. The turnover is being removed and there will no longer be a requirement. If you are less than 50 employees, you will now be excluded. Okay, I just want to be clear that there are things relating to if you have labor broking staff and that sort of thing. If you're a TES, there are different things with regards to who must report. So who is required to report on a TES? Is it the actual employer or is it the person employing that TES? Now, they were very clear that there are going to be some changes in terms of who is required to report those people. And if you are part of a TES or you have TES staff, it's quite important that you understand who is supposed to do that, because you don't want to get into trouble down the line for failing to report. Okay, so with the changes, if you're less than 50 employees, you will no longer be designated. But to be very clear, for this submission 2023, if you are less than 50, but your turnover exceeds Schedule 4, you are required to submit. If you do not submit, they can come back later for failing to submit, and you could be liable to a fine because you have not complied with the current employment equity legislation. Okay. The second element is that the minister, and a lot of talk went into the sector targets. There are 18 sectors that are going to be identified with their subsectors, and those sectors are going to be issued with sector targets. Now, they did raise, if anyone has seen the sector targets, you will notice that many of them don't add up to 100. So within the sectors, you've got top management, senior management. So each of them in the different sectors has a different target. So there's top management, senior management, professionally qualified and middle management, and then there's skilled technical. Now, in each of those, a lot of them don't add up to 100. Now, just to be clear, that is not because they need to add up to 100. That is to say that what they're wanting you to achieve is that is the minimum. Okay, so that is the minimum that they would like you to achieve. So if we had a look at, for example, in Limpopo, in particular levels, the target is 0.0 for colored males, as an example. So everybody was then concerned to say, well, are we not allowed to employ colored males? The way that the sector targets are going to work going forward is that is a 5-year target, and that is the minimum that you need to achieve. If we look at the economically active population, which works it out to 100, is they're saying that is the maximum. So if we look at African males, for example, it is 45.4%, or it's round about there, is that is what you need to achieve. You need to get to 45%. So that is almost your maximum in that particular thing. The sector targets, on the other hand, say, please, can you try and reach this minimum? What you do with the rest of that percentage, so if we're looking at 60%, you have the ability to do what you want with the other 40%. Okay, so that is how the sector targets are going to work. So you have 5 years to try and reach those targets. I do need to be clear, though, that they were very specific. So part of our changes, which I'll go through shortly, is that on the plan, you will have to set your own individual annual targets for the 4 years to hopefully get to year 5. When we're submitting our reports, is you're going to have to, so your employment equity report is going to have to submit what your targets are. Those targets don't change when the submissions come in. Those targets don't change. So in year 0, so let's assume it's next year, year 1, which will be 2025, they're going to say, what did you say you were going to achieve? Now let's see what your current workforce is, and let's see what the differences are. And then you're going to have to answer to those, which we now have justifiable reasons, which I will then explain to you shortly. But you won't be able to manipulate your plan and do whatever it is that, you won't be able to change it. You won't be able to manipulate it to change it according to changing needs. Once you put your plan in place, that is what you're going to have to do. And your plan needs to be in line with trying to achieve your the sector targets. Okay. When we then have a look at when we then have a look at the sector targets, so they have issued for us proposed sector targets, but at the roadshow, they almost implied that those were going to be reviewed again and then resent out. So we do have proposed sector targets, but I'm not sure if those are going to change. But it's quite important, and my suggestion is that you try and use those in line with your economically active population, just to get an idea of what is possibly going to be coming into effect. Okay. Now, one of the key things with the amendments is that what they're wanting to do is to try and incentivize or encourage compliance to achieving the targets by giving everybody an annual compliance certificate. Okay. Now, that annual compliance certificate currently, or what the legislation says, will be required if you're going to do tenders or any business with the state. So if you do not have that compliance certificate, you will not be allowed to do any business with the state. I'm not entirely sure if this will happen, but I suspect that what may happen is with BEE is that what they will start to do. So currently they ask, excuse me, they ask for your acknowledgements of submission. I suspect that once the legislation comes into effect, they will change it, and instead of giving the acknowledgement of submission, what they will do in order for you to get your points, because you need to submit to equity, they will ask you for your compliance certificate. But at the moment, so if you don't do work with the state, if you don't have BEE, then you may not necessarily need to get your compliance certificate. But that will be one of the things in order for businesses who do tenders and possibly even doing work with massive corporates. They may also, just by virtue of submitting, of putting out a tender, say that that is one of the requirements. So the compliance certificate, and I'll go through now, how are they going to do that? The compliance certificate is going to be something that they are going to be bringing forward. At the roadshow, they showed us the system in which we can apply for it. So it is something that's going to be coming into effect. As I've mentioned before, with the target, one of the things is that the online system is going to be set up, that they are going to be able to identify what did you say you were going to do versus what did you do? Now give us reasons for the differences. Okay, so that is one of the things that are going to be coming into effect, and you will have to answer. Okay. Just very quickly, I wanted to go into the solidarity, and then hopefully I'll be able to answer some of your questions shortly. But in terms of so solidarity referred a dispute to the International Labour Organization, and the ILO then referred it back to CCMA for resolution. And on the 28th of June, there was a settlement agreement between the government and Solidarity. Okay, and what that did was that put in place, or in writing, certain things. Okay, so what it did now, I've read the agreement now. A lot of the things that are in that agreement are actually, when you read the legislation, are actually in the current legislation anyway. All that agreement did was it just solidified and possibly put in black and white in plain English, so nobody could interpret it one way or the other, put in place what inherently is actually in the Act anyway. Okay, so the one thing that it did was that affirmative action is acknowledged as a coherent package of measures. So it's not just one thing. It is temporary in nature, but affirmative action is a number of different things. So as I said in the beginning, affirmative action, very often the way that people understand it is that it is something that is applied in the country. So in the country, affirmative action is only for a particular group or a particular race group. And that is not how it works. Affirmative action is based on the barriers that you are facing in your workplace for groups that are underrepresented. And each workplace may be different. So the affirmative actions that you put in place in your workplace are not going to be the same as what I put in place in my workplace. Or they may not be the same. So we need to look at our workplace to put those in. Secondly, is they said that affirmative action should be applied in a nuanced way. And the economically active population stats is one of the many factors that we take into account in the compliance and the analysis of affirmative action. So it's not just about the economically active population. There may be other barriers when we're looking at our workplace that say this is something that we have a problem with. It may be the economically active population is one of those elements. No absolute barrier may be placed upon employment practices affecting a particular group or person. So really what that is, and that, for example, so one of the issues, as I mentioned in Limpopo, there was the sector target of 0.04 coloured men. So what in essence is saying is that you cannot stop us from employing anyone. So there cannot be a rule in place that says we do not employ females, we do not employ white males, we don't employ coloured males. There cannot be an absolute barrier. Okay, and then when we look at the preparation and implementation of the plan and the compliance of affirmative action, the following must be considered. Okay, now this is really important, but again, I want to say this has always been in place. Okay, so these are things that have always been discussed and have always been things that we need to take into account. So as I mentioned before, the inherent requirements of the job must be key. We cannot just employ people just because they look a certain way or the color of their skin is a certain way. So when we look at our plan, we consider inherent requirements of the job, the pool of suitably qualified people, the qualifications, skills, experience. And what is quite important as well is that the ability to get those within a reasonable time frame. So as an example, if I've got a scarce skill and I need the position filled, I can leave that position open for 3 years in the hopes that I get what I want to get. But if I have an urgent business need and the only person that I can get who can do that job doesn't tie in with my plan, that is something that is acceptable. The rate of turnover, so if there's no natural attrition, that is a clear barrier to employment equity, because if there's no changes in position, if there's no additional positions, there's not much that I can do to make changes. Okay. Then no penalties or any form of disadvantage will be incurred by an employer if in the compliance analysis there are justifiable and reasonable grounds for non-compliance. Okay, and then again, I want to say this is just, you cannot terminate someone based on affirmative action. So I cannot say I have too many females, I have too many white males, in the POPA I have colored males. Sorry. Affirmative action says I've got too many of you, so I'm terminating you because of that, because that in essence is actually unfair discrimination anyway, based on section 6.1. So these things have been put down in an agreement, and these are things that we can as employers put in terms of our plan, because it has been put in agreement and it is actually part of the Employment Equity Act anyway. Okay, all right. Okay, so just in terms of things that are possibly going to be changing, well, will change, sorry, not possibly. The online system is remaining the same as it has been for the last couple of years, but the new system is going to allow, so as a non-designated employer, if you are under 50, you will still have a profile, but there will be no ability for you to capture your EEA2 or your EEA4. So you will not be able to do that. What you will be able to do is to apply for the compliance certificate, which I will talk about shortly. But what they're suggesting is that at the time when the legislation changes, if you're no longer designated, do not deregister, because if you do need the compliance certificate, the manner in which you do it is going to be on that online system. So you still need to have your profile so that you can apply for the certificate. So the new system will only allow people who are over 50 to capture your EEA2 and EEA4. As I've mentioned before, the EEA2 will now incorporate your annual targets, so from your plan. Okay, so like I said in the beginning, well, at some point in the webinar, is that your EEA2 does not come first. Your plan and your analysis, so it's your analysis, then your plan, and then your EEA2. It's not the other way around. So now your EEA2 will incorporate on the online system, what are your targets that you have set for year 1? And then I'm going to hold you accountable to that. What are your targets for year 2, 3, 4, and then ultimately at the end? Okay. So what are you saying that you're going to do? And so we need to have the plan in place before we can even submit that. Okay. All right. So then when we have a look at the compliance certificates, so the compliance certificate will be applied on the online system. So it is an automated thing that as soon as you submit your EEA2, and then obviously when we go down a year down, once the legislation has changed, they will say, did you meet your targets or didn't you? So have you done what you needed to do? So for an employer that is over 50, they will ask you certain elements of other elements of compliance, which you will then say yes, no, yes, no, yes, no. And then they will say to you, did you meet your targets? And then they're going to ask you, why did you not do it? You will automatically get that certificate. So you will get a certificate that will be printed out and that you can use going forward. What will then happen, and I'll go into 2 other elements that are now required, which I've mentioned there, and that'll be for both, is what will then happen is if you get that certificate, as a designated employer and you get an inspection and they find out that you actually haven't complied, so you just said what needed to be said to get that certificate, at any one point an inspector who does an audit can remove that certificate from you. So you will automatically get it, but then at audit you need to almost provide the proof and the justification, and they need to agree with whatever you said in line with what you submitted. If they don't agree, they can then remove it from you. Okay, and then obviously refer you to Labour Court if you haven't done what you needed to do. So two other elements which now apply to both non-designated as well as designated is the other element, which is if there's an award. So if you're a designated employer, you need to meet your targets or whatever, but in addition, you cannot have any awards. So i.e. you can't have any awards against you at CCMA or Bargaining Council in the previous 12 months of either harassment and or failure to pay national minimum wage. So in other words, have there been any cases at CCMA in which you have lost for harassment or for national minimum wage, or both? Okay, if you have that, even if you've complied with everything else with equity, you will not get your certificate. Which is why you can see now why it is quite important for you as your employer, as the employer. Harassment is no longer just a policy. There's quite a lot of things that you need to do to ensure that you are compliant, so that if somebody does make a claim, you know what to do and it's dealt with correctly, so there will not be a claim for you at CCMA. Those people that are under 50, so non-designated, you will not be required to submit a report. There will not be a requirement for a plan. You don't need to have a committee. You don't need to do any of those things, but you can still apply for your compliance certificate. And the two elements that you need to do in order to comply is, one, you cannot have any cases at CCMA or awards against you at least in the previous 12 months for harassment or failing to pay national minimum wage. Okay, so as a non-designated, you can still get that certificate. It will apparently be a different looking certificate, so it'll have a different format or it will say something different, but there are elements for both organizations to get that. Okay, so there's a lot of information in an hour. So if you have any queries, I know that there's some questions which I'm going to look at now. If you have any questions, please feel free to email us. We do have, if you want to, we've just updated our pocket guide for managers on HR and payroll. You can scan the QR code there and you'll be able to get it on your phone. If you want the recording you can get off our YouTube channel. It will be available there in the next day or so. So it will be on our YouTube channel. And so we will, it will be there for you to have a look at. So we do have a query with regards to weak economic growth. So that is one of the reasons why you may not be able to achieve your targets. So if we look at why you can't achieve your targets, there are 7 different reasons. I'm not going to remember them all now, but one is, there's no turnover, no recruitment opportunities, no promotion, weak economic growth, and there's 3 others which I can share with you afterwards in terms of why you don't meet your targets. But those will then be listed on when the system changes, as it says, why have you not met it? And then you will need to select one of the 7 reasons as to why you have not met it. Okay, I'm just having a look at some of the other questions. Okay, so Wendy, you asked if you have less than 50 with a turnover that meets the requirements, do you need an equity committee? Yes, unfortunately, you do need an equity committee. So everything that I've spoken about in terms of the plan, the analysis, the committee, currently you would need to comply with that. But when the changes come through, then you won't need to do that. But unfortunately, at the moment, you would need to do that. Okay. So that brings us to the end of our session today. I do hope that it's been informative. I hope that I've answered some of your questions. As I've said before, you can download a copy or watch it on YouTube. It will be available there for you to watch, down the line. And if you do have any queries, please can you email us either at info@hrtalk.co.za and or you can email hra@hrtalk.co.za. Thank you very much for joining us today. We hope to see you next week. or whenever our next webinar is. Thank you so much.